are they receiving the full benefit of the law as contemplated by Article 27(1) of the Constitution? Then it also raises another dilemma under Article 50, Clause 2p, I think, Clause 2p of the Constitution, Clause 2a of the Constitution, which gives the accused persons a constitutional presumption of innocence. Will that principle apply where where the witnesses are the accused? So before we can take off, we wanted the court to be alive to those emerging realities, and I will allow my learned colleagues also to give input to that foundation, that if we proceed the way this case is structured at the moment, there will be a plethora of violations of constitutional rights as already enumerated under Article 50, Clause 2L, Article 50, Clause 2B, Article 27(1) of the Constitution. And remember, Your Lordship, if you look at Article 159, 2E, it obligates this court to apply, promote, and protect the constitutional principles. These are the principles, Your Lordship. And these principles are not just paper aspirations. They have been enacted by the drafters of the Constitution so that they protect the accused persons. So, if the prosecution can give us guarantees that the accused persons are not the main witnesses in this adjudication, then the trajectory of this case can change. But if, as supplied by their statements, the accused persons are the main witnesses in this case, then we have a serious constitutional dilemma, and we do not want to take off before that dilemma is clarified by the court and even the Superior Court. I will allow my colleagues to highlight the subpoena further on that account.
Your Honor, that is not just a constitutional dilemma alone that my senior has submitted to. It goes to the roots of the propriety of this trial. Propriety in the sense that in addition to what my senior has submitted on in respect to Article 50, that is Article 50, Clause 2, you'll also look at paragraph J. To be informed in advance of the evidence the prosecution intends to rely on and to have reasonable access to the evidence. Up to now, we do not have reasonable access to that evidence because the witnesses are the accused persons. This can only happen in a jurisdiction where there are no procedures, and especially as enshrined under Cap 75. Secondly, Your Honor, paragraph K provides that to adduce and challenge evidence, the prosecution to adduce evidence, the defense to challenge that evidence. So we are in a serious constitutional dilemma, as counsel says. How do we challenge this evidence? How does the prosecution adduce this evidence? When does the accused person convert from an accused person to a witness? And where is the line? Counsel submitted on the question of to refuse to give self-incriminating evidence. And Your Honor, this is a very, very, very serious transgression because this Article 50 is protected article under Article 25. Article 25 says that these are some of the non-derogable rights You cannot derogate this right. You cannot limit this right. The right to a fair trial. And as such, Your Honor, many a times this court has said that it has no ability to interpret or apply the Constitution. But we are not asking you to interpret it. We are asking you to apply it. Just in the same way, you would apply the provisions of the Constitution and Article 49. If you could grant an accused person bail under Article 49, and that is the application of the Constitution, why then should the court close its eyes to the import of Article 50? You know, as I sum up and perhaps pass over to my learned friends, it is important also to look at Article 10. Under Article 10, which provides for the values and principles of governance, this court is enjoined. This court is enjoined in its jurisdiction to uphold the provisions of the Constitution. Among that principle, Your Honor, is the principle of the Bill of Rights, to which we are submitting to this morning. So, Your Honor, we are in a serious dilemma. And may I just mention that the evidence of Daudi Mwangi Chege, the evidence of Daniel Mutua Njoroge, the evidence of Simon Mungai Madhu, the evidence of John Kuria Kariro, the evidence of Peterson Wanjau Ndirango, the evidence of Samuel Kangede Gige, the evidence of Julius Dongo Kamau, the evidence of Peter Njenga Wambui, the evidence of Philip Kagiri Njoroge. Your Honor, those are your witnesses today. These accused persons are your witnesses. Your Honor, we are ready to proceed in that circumstances, if we can.
Good morning, Your Honor. My name is Harold Ndubi, advocate. May I apologize? I was actually running upstairs to look for you to come here so that we can deal with this matter. The questions that they have discussed, my colleagues have discussed, are important constitutional questions. We are in a period that now we want to violate the Constitution and defile the Constitution at the behest of the prosecution and in promotion of impunity. We expected that the Constitution of Kenya, and if you allow me some bragging rights,